Great. Are we on?
Yes.
So if y'all can hear me, y'all type yes in the chat. Because you know I'm always paranoid about these things, about whether or not people can hear me.
Okay, there's yeses coming.
Groovy. Thank y'all. We want to welcome you to our training on 504 Explained. As you can see, this is a hybrid training, so I have people in the room with me, which I'm always excited about, as well as people online. So I want to welcome y'all all. My name's Melinda Elliott, and with me is Wallace Johnson. We're your presenters for this training. We're going to cover some of the basic points about 504. In order to keep getting funding to provide these 3 trainings, there's going to be an evaluation at the end. The evaluation results help us improve trainings and demonstrate the need for continued funding to provide these types of trainings to our community free of charge. You're going to be prompted again at the end to complete the evaluation. It's easy, 2 minutes. It's quick. Everyone completing an evaluation will get a copy of this PowerPoint and a certificate of attendance. If you lose audio, you can rejoin the presentation using the login information you got in the email you got after you registered. My experience is that if you stay on for probably less than a minute, Zoom is going to link you back up so that you're going to see things again. But you can always go back to that email and use either the phone number in the email or the link in the email. You can put questions in the chat box as we go. I'm good with that. You can also wait till the end during the question and answer time if that's what you want to do. Families Helping Families of Southwest Louisiana provides dozens of webinars and in-person trainings on special education and disability-related topics every year. You can check out events on our website, www.FHFSWLA.org, on a regular basis and register for any upcoming trainings that might be of interest to you. You can also request specific trainings that aren't being offered. The easy way to do that is somewhere in the fill in the blanks on your evaluation, write in, I'd like to see a training on. It can be trainings that we've done before, trainings that you think that people with disabilities, including yourself, would be interested in. You know, if you're interested in a topic, there's other people interested. And y'all forgive my throat loss, and it's that time of year. The voice doesn't want to work right. So I also have the pleasure of being the LECAN, not only an education specialist at our office, but the LECAN team leader for Region 5. LECAN stands for the Louisiana Council Advocacy Network. We are the advocacy arm of the Louisiana Developmental Disabilities Council. Wallace is probably dropping the link in the chat because Wallace is good about all these things. But when you get this, you're going to have information about being able to join. Joining means you're going to get email. We do things around developmental disabilities and services for people with developmental disabilities, as well as special education. We are currently taking community input into the council's legislative agenda for next year. That information will be looked at by what they call the ad hoc legislative committee of the Louisiana Developmental Disabilities Council. They'll come up with a tentative agenda, which will go to the full council, and the full council makes the ultimate decision. There's somebody like me in every region of the state. Region 1 and 10, these are LDH regions, by the way, because there's different regions depending on your agency. But there's one of me everywhere. So there's people in your area that know about your issues and that know about the people in your area. You join and you're getting emails. You're getting emails about the service system. You're getting emails, lots of emails during legislative session about the things that we're working on and things that come up. We have a round table in usually February, March. We have good representation in Southwest Louisiana from our legislators. I think 4 out of 8 of them usually, 3 or 4 out of 8 of them usually attend. Both of our senators attend in our area, which is awesome. We have individual visits because my job really isn't to talk to the legislators. I do and I will, but they see me all the time. They want to talk to their constituents, right? So my job is to hook everybody up with their constituents. But, we're moms, dads, grandparents, siblings, people with disabilities, people in the service system, people that are care about people with disabilities. And well, if you're in my area and you can hear my voice and you want to come by the office and give me time, I will find you one of our pretty yellow shirts. They're yellow and teal. Because we're hoping you're going to go to Baton Rouge, or if you're on a virtual meeting that's about LeCan, that y'all can send me pictures. And not everybody can go to committee meetings in Baton Rouge all the time or yellow shirt days. Sometimes people send me pictures or Facebook pictures of them watching the legislative committees, because we're lucky in Louisiana. They show those from the legislative website. And some people are going to have stories. I'll help you with your story. I'll help you put together an impactful story about one of our issues, maybe. And you can use those in all of those places too. Committee meetings, individual visits, everything. So, I want y'all to understand, I'm not a lawyer. I'm not providing any legal advice. If you have any questions and I answer them, those responses are in the context of what I think might probably happen in most situations. As we go through the training, if you have any questions, hit me up in the chat box. One of us is monitoring the chat box, more than one of us, by the way, so we can answer questions as we go along. There'll also be a time at the end of the training when you can ask me more stuff. There's no question too small or too hard. If it's your question, it's important to us, so ask away. 504 is a broad topic and covers a variety of issues, from public building access all the way to educational access. Today, we're going to focus only on the educational issues that are relevant to your child's obtaining educational opportunities, just like a child without a disability would. We're close. Before we finish this session, my goal is that you have a better understanding of 504 and how it can be determined, say that fast, if your child might qualify for services under the umbrella of 504. Knowing about 504 is only the beginning, because it's going to help you to understand how 504 can help your child if he or she is struggling in school. Last, we're going to offer some insight into what kinds of accommodations might be appropriate for your child to better access the instruction at school that's offered to all students. Okay, so let's get to the meat and potatoes of today's presentation. Section 504 of the Vocational Rehabilitation Act of 1973 was passed to ensure all people have equal access to buildings and opportunities, regardless of their disabilities. When it's first passed, it was geared mostly towards federal buildings. But as time went on, people with disabilities and their families wondered why equal access couldn't be expanded past the federal buildings. So through their advocacy work and lobbying, in 1990, the ADA, the Americans with Disabilities Act, as it was called, was passed. The ADA is a civil rights law that prohibits discrimination based on a person's disability. The ADA Amendments Act of 2008 or ADAAA. I get lost in all that soup, all the alphabet soup. But anyhow, it's an act of Congress effective January 1st, 2009, that amended the Americans with Disabilities Act of 1990 and other disability non-discrimination laws at the federal level of the United States. The act emphasized that the definition of disability should be figured in favor of broad coverage of individuals to the maximum extent permitted by the terms of the ADA and generally shouldn't require extensive analysis. The act makes important changes to the definition of the term disability by rejecting the holdings in several Supreme Court decisions and portions of the EEOC's ADA regulations. The effect of those changes is to make it easier for an individual seeking protection under the ADA to establish that he or she has a disability within the meaning of ADA. That's important because it sets up one of the fundamental differences between the identification of a disability under 504 and under special education, IDEA, Individuals with Disabilities Education Act is the name of that law. A frequently asked question is, who does 504 fix? Teachers and principals are frequently surprised at the answer to their question. The reason they're surprised is because the answer is nobody. And there should be a pause. And then in addition, because students who are eligible for 504 are broken. The next part of the explanation is the purpose of 504 is to level the playing field through accommodations, extra supports, and services. Many people then tread the dark waters of, well, that's not fair. I hate the statement, that's not fair. But okay, the next part of the discussion should be, okay, let's talk about fair. I think children in wheelchairs might think it isn't fair they can't walk like many of their friends. Or teenagers with a significant seizure disorder might think it isn't fair that they can't drive a motor vehicle like most of their friends. The child who struggles just be able to identify numbers and letters might think it's not fair that they can't read as well as their friends and peers. You know what? It isn't fair. 504 provides teachers and administrators the ability to level the playing field so that a child with a disability, the child's disability doesn't inhibit their ability to participate. It gives them opportunities to participate. Is it unfair that a child with a wheelchair has to use an elevator to get to the second floor to go to classes? The elevator lets the child in the wheelchair have equal access to the classroom. So why is it unfair for a child to get extended time to complete his tests? The short answer is it isn't unfair. There are many people involved in determining whether a child has a disability or not, whether they're eligible for 504 or not, and who will then also be responsible to monitor the effective implementation and delivery of those services. While they're all extremely important because of what each brings to the table, it's the principal or his or her designee. Lots of times I see vice principals that's able to allocate the appropriate resources. Notice I didn't say counselor, but that person is able to allocate the appropriate resources to ensure that all accommodations agreed upon by the committees will be available and provided. Because that principal's role is very important, they need to be available there, present for the entire meeting. If the principal needs to leave, you need to pause the meeting. If they have an emergency that's going to be longer than expected, then you need to reschedule the meeting. That's how important it's for that person to be there. I'd never let a 504 meeting go without the principal present under any circumstances. Then the school building level, they call it the SBLC chair, is usually there to ensure that all the topics of concern are addressed and that everyone who needs to be at the meeting is informed of the meeting, its location, time, and purpose. You need, if you, at a 504 meeting, you need the general ed teacher, because it's the general ed teacher who understands grade level expectations, grade level curriculum, and how that knowledge needs to be demonstrated. The parent has a right, and I'm going to say a responsibility, to be present to discuss their child's educational needs. Then whenever it's appropriate, I'd like the student to be there. This way, the process becomes something that's for the student instead of something we're doing to the student. It also helps the student to learn to advocate for his or her own needs. That skill is going to become increasingly important as the child gets older and as soon as they're an adult. As soon as they're an adult, it's their ball game. They need to be able to advocate. And watching mom or dad advocate is the best way for them to learn. I suggest a pupil appraisal person be at the meeting. It's not technically required at every meeting, but that pupil appraisal person is the one that sheds light on how the child's disability might impact his or her learning. Anyone else who can bring to the table important information about the child's learning, behavior, or any of those kind of things. It could be somebody that the parent wants at the meeting for moral support or to help them advocate, possibly even an attorney. The school system has to tell the parent who they're inviting to the meeting. The parent doesn't have to tell the school system if they're bringing someone, but come on, as a courtesy, I'd suggest you do that. You want to develop and maintain a positive relationship from the very beginning, from get-go. While it's only a suggestion, I'd always let the school system know if you're bringing in an attorney. Because if you go to the meeting with an attorney and the school hasn't been notified, that they will, I'm not even going to say may, they will reschedule the meeting so that they can make arrangements for their own attorney to be present. And that's a delay you and your child don't need. You can avoid that by letting them know on the front end.
I do want to pause, if I may.
Sure.
So you said the counselor doesn't necessarily need to be there, or need to be. That's not the part.
Sometimes people think that when we're talking about 504, and sometimes they're directed to the counselor, when in reality, the counselor isn't the person. The person is the principal or his or her designee, generally the vice principal, hardly ever the counselor. And I don't know how many parents I bump into, whether it's 504 or special education, that have been talking to the counselor for 2 years. And I have to say, no, that's not where it's at. You either go to this person, or particularly 504, the principal is where it's at.
Okay.
Yeah, that's a surprise quite often. Yes, ma'am.
And is it because the counselor doesn't have the resources to do like the other two have, right?
No, that's
So
not
that's not it.
No, that's not it. It's the way that it's set up in the school system, that the principal is the 504 person. So, okay. Where am I? Okay. Remember, not every child is going to be eligible for services and supports under 504. Just because they have a disability isn't enough. So let's talk about how that eligibility is determined. Before a student can be determined eligible, someone has to indicate the child has a problem. Someone could be mom, dad, school official. It could be the child themselves. I don't see that happen very often, but it could be. The question then arises, does the parent request, because that's what has to happen next, the parent request have to be in writing. The technical answer is it depends. Yes, it does have to be in writing, but what if the parent doesn't write? Does that mean that the student loses their eligibility to be considered for 504? No. If for any reason a parent can't put the request in writing, school personnel need to be creative. They can write it out and have the parent sign it. The school personnel can make the request themselves. The parent can sign for the evaluation, make their mark for the evaluation. You do all the things that you would do in another situation where you needed somebody's signature, right? There's lots of ways to figure that out, but there's no way that around the fact the parent must sign a form for the school to do the evaluation in some way. If the parent refuses to sign the paperwork giving the school permission to conduct an evaluation, then the school can't do it on their own. Now, once the parent signs it, then the school can keep it up, but the parent still also has to sign for services to begin, which is a whole nother thing. When requesting a 504 evaluation, the parent must indicate the areas of concern within the written request. So there might be things like academic difficulty, like problems reading or comprehending written text. Can be behavior. 504 does work for behavior. Consistently violates school rules, is routinely getting suspended. It could be medical reasons. The child has diabetes that might require visits to the nurse during class time or some other medical thing. The number of other things that you could come up with quite possibly can be as many as the number of kids. Okay. If there's some kind of condition, some kind of reason, then we need to talk about that. Because the law doesn't give you an extensive list. The definition of disability under 504 is different than the definition under the Individuals with Disabilities Education Improvement Act idea. Under 504, a person with a disability is one who has a physical or mental impairment that substantially limits a major life activity. We're going to talk about substantial limitations in major life activities a little bit later, but another criteria is as to whether or not a person has a disability under 504 is that the person has a record of having a mental some kind of impairment, or they're regarded as having some kind of impairment. That term regarded as having an impairment, it's hard to wrap my brain around, right? So lots of research, lots of discussions. It's not so much for the initial eligibility as it is about the anti-discrimination component of 504. Whether an individual is or is not determined to have a disability under 504, if another person takes action against the individual, such as bullying, physical aggression, any of that type of stuff, and the negative action is because the aggressor thinks the person has a disability, then the aggressor can be charged with discrimination. Okay? So let's say, kids are kids. Let's say that they think that somebody has what hopefully these days we all use the term intellectual disability, but kids use the R word. that can be considered discrimination if he's bullying another kid. And that in October, my commercial, in October, we're having a bullying law webinar that y'all might want to be involved with. Or y'all might already know a lot about it, or might want a refresher. But yeah, and I can talk about those. Wallace and Beryl is our other education specialist, can talk about those things at other times. You don't have to wait till October, you guys, okay? All right, so let's talk about the major life activities. See my list? It looks like a long list, but that's only some of the major life activities listed in the regulations. Those regulations clearly stipulate this is not an all-inclusive list. Other activities might be reproductive functions, functions of the immune system, cell growth, digestive functions, bowel and bladder functions, neurological, brain, respiratory, and circulatory functions. Even with all of those that I'm saying, the regulations indicate that list still isn't exhaustive. The long list, coupled with the more relaxed approach to eligibility determination stated in the 504 law, makes it much simpler for a person to be eligible for 504 services than is the case for special education eligibility. You move on. So what exactly is substantial limitation? That depends. That's enough. All the depends. There's no definition provided in the law, regulations, or guidance regarding 504. The 504, using the evaluation data, must determine whether or not there's a substantial limitation. Some of those determinations are really clear. If a child's in a wheelchair, his or her mobility is most definitely substantially limited. But what if the child has a seizure disorder but hasn't had a seizure for 2 years? Is there a substantial limitation? Well, that answer should be individualized to that child being discussed. And sometimes the answer can vary from one student to another. If the parent disagrees with the 504 committee, the parent has the right to follow the due process procedure that each district must have specified for 504. It should be noted that to date, the courts haven't defined substantial limitation. And in the end, it's probably going to be a court that creates some sort of definition. Until that happens, it's more than likely going to be inconsistently interpreted. That's why parents need to know how to use those due process rights. Before a child can receive any services or supports under 504, he or she must first be determined eligible. So what does that mean and how it's done? Let's talk about that a little bit more. So here's a little poll. Y'all share y'all's opinion with me. Y'all chat. Put it in the chat box. A 504 evaluation consists of only one test to determine whether or not my child will be eligible for 504 services. True or false? So I'm going to wait a few minutes for people to type in my chat box. How many people are with us today, Wallace? Do you know?
It says there's 12 on,
Oh, cool.
and one of those is me. Actually, it's 11, 12 counting me,
Nice crowd.
and then everybody here.
Are people answering?
Let's see. I see some falses. Let me scroll up and see if I missed any. So I see false. Several falses.
Okay, what do y'all think? Oh, false? Yeah. Okay. Y'all are good. Evaluation is not a test, it's a process. In order to determine eligibility, the school must conduct an evaluation. It must be understood that an evaluation isn't a test, it's a process. The process will include some testing, but it can include interviews with the parents, the student, the teachers. It's critical that student data be reviewed in order to determine whether or not the student's having problems in academics, behavior, communication, health, any other area. Academic data reviewed should include grades, standardized testing like LEAP scores, progress monitoring like STAR, Renaissance, levels, work samples. Behavior data should look at office referral, and I'm talking about minimum things here. Office referrals, conduct grades, if the school is using PBIS, positive behavior intervention and supports data. Communication data would include information from parents and teachers regarding the student's ability to articulate his thoughts or her thoughts verbally or in written form, prior hearing and vision assessments, information from parents and teachers. Then you can decide whether or not further communication assessment is warranted. Health information can be from the parents, the school nurse, if the child has a medical condition, medical records might be shared with the school, so that the child's eligibility can be more accurately determined. Plus, if eligible, knowledge of medical records can help the 504 team create a better plan.
Can I ask a question?
Mhm.
As far as the behavioral evaluation, how much truth is there in the schools that are saying things like, we won't do a 504 evaluation until they have 3 write-ups? Like them setting this hard line.
So, the 504 evaluation is basically about them having a substantial, the 504 plan is basically about them having a substantial limitation to one of their life areas, not about them necessarily being in trouble or not. So I'd probably go to the 504 coordinator for the school and sort of climb up that chain of command in that particular area. Because waiting until, it's kind of like, let's wait until they fail. That shouldn't be necessary or fair for our children. But no, the 504 plan is if they have major life limitation in areas, and it shouldn't have to be evidenced by write-ups.
Okay. And on the same hand, if a parent is requesting an IEP and a 504 evaluation, just cover all the bases. And before you even get into a meeting, they're saying he doesn't qualify for an IEP, his grades are good.
So yeah, you're getting into a real detailed conversation about their grades are good versus the support that they need to be able to stay in school, maintain in school, and that's kind of a different kind of conversation that I would probably need more information from the parent to be able to address. But no, that shouldn't be. Yeah, no, you shouldn't have to wait until they're failing. I mean, that's just not reasonable. I know, and I'm aware that parents are told that all the time, but that's just not reasonable.
And these are good questions, by the way. Good questions.
Yes, ma'am. Sir. Okay. Do we have any, I usually ask somewhere in here, do we have anything in the chat box?
I don't see any at this time.
Okay. So, am up to, how long will the evaluation take? Once the parent signs the paperwork giving permission for the school to conduct an evaluation of the child, the school has no more than 60 school days to complete the report. Notice that I said school days. I didn't say calendar days. So school days don't count weekends. Schools don't count holidays. So When we're talking about 60 school days, people hear 2 months. That's not right. Easily, if you're not counting the weekends or the school holidays, you could be into 3 months or more. Just to highlight that. Once the initial evaluation is completed, the school building level committee must meet to review the evaluation data and determine the eligibility status of the student. The process to determine 504 eligibility is not supposed to be as rigorous as the eligibility process for special education. That's included in the letter and the spirit of 504 and the regulations. So it shouldn't be that he didn't qualify for special education, so he doesn't qualify for 504. It's often, and it is often, he didn't qualify for special education services. Let's look at 504 because the eligibility isn't as strenuous. How does the SBLC make that determination? The SBLC determines eligibility by answering 3 questions regarding the student. Now, what exactly are those questions? The first question is, does the student have a physical or mental impairment? The data contained within the evaluation report should indicate the answer to that question. If the answer is yes, then the nature of the parent, like the diagnosis, must be described. This would specify the disability under 504. Could be things like ADD, ADHD. Surprisingly, those aren't classifications because special ed is about classifications. Those aren't classifications. Your child might have those and might qualify for special education, but it's not things under special education, but it is things under 504. Diabetes, seizure disorder, math learning disability, reading learning disability, anxiety, or a host of other possible disabilities. So let's look at a simple scenario. Most scenarios aren't going to be this clean cut, you guys, but for today's training, we're going to keep it simple, right? After the evaluation is complete, the SBLC reviews the evaluation, which contains medical records, which state the student has a diagnosis of muscular dystrophy. As a result of this condition, the student is in a wheelchair. So the first answer to the first question is yes. The student does have a physical impairment, and that impairment is his inability to walk without assistance. Once the SBLC has determined the presence of a physical or mental impairment, and it has identified the impairment, the next question is going to be, does the physical or mental impairment affect one or more major life activities? If the answer is yes, the SBLC must determine which life activities are affected and how they're affected. So let's go back to our child in the wheelchair. It's been determined he does have a physical impairment and he can't walk without assistance. So the major life activity that's affected would be mobility. Are we still all together? So now we have determined he has an impairment that limits the major life activity of mobility. We have to determine whether or not the physical impairment substantially limits a major life activity, and if so, which one? Now, at this point, we know it's just affecting the major life activity. It has to be determined whether or not it substantially limits that major life activity. In this scenario, the SBLC might well determine there is a substantial limitation. Substantially. Neither the law nor the regulations have guidance in 504 that provides a definition. So it's each SBLC which must make the determination about whether there's a substantial limitation. Because there's no definition, Each SBLC is going to determine its own criteria for making that determination. And that sort of inconsistency is what leads to disagreements and complaints. It's kind of my opinion. Those complaints are going to lead to legal proceedings. And at some point in the future, it will be the courts that decide something to be more consistent in the process. But at this point, hopefully, we can all agree that the answer is yes, right? That if he has to use a wheelchair, it substantially limits his life activity of mobility. Okay, good. So now what? Those three questions are important. If any one of those questions would have been answered no, the student would not be eligible to receive what we call FAPE under 504. FAPE is the free appropriate public education. Okay? There are many areas of concern that can lead to evaluation of a student and to the determination of eligibility. One of those is academic. An example, if a child is reading well below grade level, 2 or 3 more grade levels lower than his peers, and he's not responding to academic interventions, a 504 evaluation might be warranted. The child could be struggling in math, like following directions, and those would all be academic concerns, which should be investigated and addressed as well. Behavior concerns might include those office discipline referrals, suspensions, changes in behavior and mood, unusual aggression. All of the discipline data, along with the interviews of the student, his parents, and the teachers, and PBS data, which are available, are all good sources of data to investigate. So let's talk a little bit about accommodations. The discussion of accommodations is of critical importance to leveling the playing field and must be based on data. Accommodations available to students who are determined for 504 services is done in the meeting. And for want of a better way to describe it, it's where the rubber meets the road, right? So it first has to be understood that a child can be determined to have a disability as determined by 504 and not be eligible for any accommodations. An example might be a child with ADHD. He's on medication and the medication is working. The diagnosis of ADHD would probably make him or her eligible for 504. But because the meds are working, he or she isn't having any behavioral, social, or academic problems in school, there's no need for accommodations. However, should the meds stop working, and or if he has to stop taking those meds for any reasons, the doctor can decide that, yeah, this medication is wonderful, but he can't take it. A 504 committee meeting should be called to discuss accommodations and other supports that might address the student's new situation. The first thing to remember about accommodations is the sole purpose of accommodations is to level the playing field, not to give the student an advantage over his or her peers who don't have a disability. Any accommodations that provided or denied must be supported by data obtained through the evaluation process. So a student with a reading comprehension disability might be eligible for accommodations of tests read aloud, extended time, things like that. But If the student doesn't have a disability in math computation, an accommodation of a calculator wouldn't be appropriate, right? Because the data doesn't support that. That's true regardless of how badly the student, the school, or the parents want the student to have that accommodation. A student with a diagnosis of ADD, ADHD might be given the accommodation of redirection or maybe repeated directions. One important aspect of accommodations that must be considered at all times is that if the child doesn't qualify for accommodations during classroom testing, that accommodation can't be provided for state testing. So a child should get the same accommodation for a classroom test as they do for the LEAP test. It can't be one or the other. Typically, an accommodation the student gets on the LEAP must have been in the place for at least 30 days before the administration of that test. Otherwise, the accommodation can't be used on the state assessment. So frequent breaks is something that they're supposed to be getting. It's really important on the 504 plan. It's really important to make sure that frequent breaks are happening in the classroom for that student to get frequent breaks during LEAP testing. Because if you know kids with ADHD, that LEAP testing is a big bugaboo because that extended concentration is difficult, right? Okay, so that's why I'm telling y'all about this. The reason for this is if the student hasn't had ample opportunity to use the accommodation and become comfortable with it, trying to implement it on the state assessment is going to put them at a disadvantage, which is contrary to the intent of accommodations in the first place. Okay? If a student is determined through the evaluation process that he has a disability under 504, that student is entitled to a FAPE. FAPE stands for Free Appropriate Public Education under 504. You hear about that in special education too. So then the discussion is about what, if any, supports and services they need in order for him or her to have equal access to the programs and grade level curriculum in which his or her peers without disabilities are engaged. While terms, accommodations, and modifications are often used interchangeably, they're two different things, very distinctly different things. So using them synonymously, like just willy-nilly at the same time, is a slippery slope that can cause problems for the student and the school.
We have a question from the chat.
Sure, shoot it.
Would a student with a diagnosis of stomach issues be accepted for 504? And what options does the student have to keep him or her inside school?
So you go back to those three questions that I was going through before. If you can answer yes to all three of those questions, if the team can answer yes, and remember that the parent also has a way to appeal the decision. But still, in that 504 meeting, if you can answer yes, if you can prove yes to all three of those questions, then yeah, they could acquire for 504. It's not like you can say, this qualifies, that doesn't qualify, this qualifies, that doesn't qualify. You have to answer those questions. And then what was the second part of it?
What options does the student have to keep him or her inside school?
Okay, so first we have to figure out about that 504 plan. That 504 plan should be where you come up with the options, the accommodations, the processes, the things to be able to keep him in school. It's the first part of my answer. The second part is the school nurse is a resource. The school nurse can come up with something that they call the individualized health plan. It can be attached to an IEP. It can be attached to a 504, or it can be a standalone. And that health care plan is written with information from the doctor and with information about the disability and medication and different things that might be that affect the child, and can have things in it that can help the child stay in school. So there, in this particular scenario, there's two different things I want to do. Get that 504 thing kicked off and evaluation kicked off and going, and let's talk about using the school nurse as a resource for that health plan.
For the IHP, how are the parent just contacting the nurse directly to request that, or?
Parent contacts the school nurse. If there's a 504 evaluation or a special ed evaluation, it's generally part of that process that they do that as well. Not always, because there's certain triggers that they use to say, oh yeah, let's get the nurse involved in this too. But yeah, mama can call. Or, I keep saying mama, I mean daddy too. Are we good, Wallace?
Yes.
Okay. An educational accommodation, I'm still with the shoe, yeah. An educational accommodation is a support provided to qualified students that will level the playing field by minimizing some of the impact of the student's disability on his or her access to the general education curriculum. But the student's still learning the same content. They're still learning the same stuff, and they have to demonstrate that he's learning the content to the extent required as his or her peers that have no disability. Now, the way that mastery is demonstrated might be different, but the content is the same for everyone. Modification. That's why you probably shouldn't be saying modification concerning a 504 plan. A modification indicates that there's substantial changes to the content or to the level of mastery required. Those are things that we generally talk about when we're talking about students who have the most severe intellectual disabilities. And there are students that typically are qualified for special education under IDEA, the Individuals with Disabilities Education Act. Okay, back to our 504 and the accommodations. Once the 504 plan has been developed, all of the teachers are responsible to provide all of the accommodations. There you are, period, right? But if the student has behavioral issues, all personnel who have contact with the student is responsible for implementation of the identified strategies. That might be the bus driver, that might be the cafeteria worker, that could be the clerical staff, that could be the janitor staff. If they're young enough, that might be the teacher on the playground. Okay? You should ask the 504 chair when all appropriate personnel will receive a copy of your child's plan. If the plan isn't shared, not only does that violate the law, but it defeats the purpose of the accommodations, which require consistent implementation for them to be effective. If the appropriate staff aren't aware of the decisions that were made by the 504 team, there's no way any of those decisions will be implemented, and whatever problems have been present will continue and probably get worse. During the 504 meeting, when these plans are being developed, parents should also ask the team how implementation will be documented and how that data is going to be shared with the parent, as well as what frequency. How you might want to see charts and graphs they create on a weekly or monthly basis. If you don't understand that data, don't be afraid to ask for a teacher meeting. It doesn't have to be a 504 meeting, but ask for a teacher meeting for that data to be explained to you. lots of times there are questions about any mandated accommodation pairing. In other words, if a student is eligible for one accommodation, will that automatically make them eligible to receive another accommodation? So I'm not sure where that comes from, but contrary to what many people believe, there's only one automatic pairing. If a student is eligible for and provided the accommodation of answers recorded, then the student must have individual testing. The reason for this is if the student is verbalizing the test answers or their test answers, so another adult can write them down, and there's other students in the room, it's not an environment conducive to doing that. And then the other kids in the room are going to hear the answers, which creates a testing irregularity. Okay. So if the student has tests read aloud as an accommodation, he might also need small group testing, but not necessarily. So there can be, oh, my goodness, so sorry. There can also be a, like a second grader that needs the LEAP test read out loud. There might be several students in that room, and the teacher is going through the test questions one by one, and they're each answering it. That can happen, but you still need a small group, not like 30 kids, right? Like 6 kids. But or there are no other second graders that need the test read aloud, then it's going to be the teacher one-on-one with the student, right? Let's see. If the student receives the accommodation of text to speech, where the computer reads the test to the student, and the student has headphones on, he might or she might be able to be in the classroom with other students who aren't receiving any accommodations, because they're the only ones that can hear it being read aloud, right? Lots of people think that if a student has a medical condition which requires a visit to the nurse for medication administration, or if they get sick, that student should have extended time as an accommodation. And that's not always accurate. If any student gets sick or has to leave the test for a medical reason, the time they're taking the test stops as soon as they leave the room, and the time should begin again when they return to the classroom, right? And I say that to say that if it's something that all the kids can do, then it's not really an accommodation. If it's something that only your child or 2 or 3 kids in the room need to do, then yeah, it's an accommodation. But yeah, everybody, whenever you get sick, you should be able to start the test again as soon as you walk back in.
Yeah, we got something in the chat.
Sure.
Let's see. Gotta scroll down. Oh, they were saying thank you to the answers of the other one.
Groovy. Okay.
I do have a question.
Yes, ma'am.
Going back to the documentation of it. So a lot of our parents say that their meetings are held virtual, or like over the phone. So how would they get a copy? Because most of them don't know they should get a copy. So when we tell them
A copy of the 504 plan.
how,
So the school can mail it to them. The school can email it to them. The students can make a copy and send it in Johnny's book sack.
okay.
They can make a copy and send it in sister or brother's book sack. The school can say, come by and get it.
Okay.
There is no,
So
they need a mutually agreeable way for mama to have it in her hot little hands.
Is there a certain time frame where they have to receive it, or?
So there's not a legally required time frame, but if I didn't get it within 3 school days, I'd probably be, knocking, calling the principal, trying to figure out, what's going on. It should be that simple.
do y'all hear about a lot of parents not receiving it? Cause on our end, we hear, well, I've done these meetings for 2 or 3 years and I've never received a copy of anything. So I don't know whether to believe the parent, because I don't know if it's emailed or sent and the parent just hasn't been responsible
Isn't aware
enough
that they
to,
got it. Let's
right,
go with isn't aware that they got it. So no, I don't have a whole lot of parents to tell me that. I don't have a whole lot of parents that call me with 504 plans, number one. And it's as simple as pick up the phone and you say, I lost my copy. Send me another copy. So getting a copy, if you realize you don't have it, should be easy peasy. Just like an IEP. Getting a copy if you don't have it should be easy peasy, or you start climbing up that chain of command. You know, where's the breakdown? Somebody get it to me. Please.
If they're having trouble getting it from the school, they can just go to the school board or like whoever. I know that's
So,
not with the parent.
It's a little bit more complicated with 504 plans, but yes, you should be able to go to the school board and get a copy. and or you're going to go there, you're going to go to up the 504 chain until you bump into someone that's going to be able to call the school and say, this is how you get it and send it to her. But yeah, it shouldn't be that big of a problem to get a hold of that sucker.
I have a contact that emails me.
okay.
There's a lady at the school board office, a records lady. Can't remember her name right this second, and yeah, it should be that easy. Okay. We're up to another poll, right, Wallace?
Mm-hmm.
Okay. The statement of the poll is a 504 meeting can be held only once per year. Is that true or false? Y'all type it in the chat. Is anybody answering?
I see some falses coming in, several of them.
Good. So, to ensure that the plan is being implemented and that it's yielding positive results for the student, the 504 plan must be reviewed at least annually. But student progress should be monitored much more frequently by the parent, by the teachers, by the 504 committee. During that annual review, data for the past year should be collected and reviewed in order that data-driven discussions may be conducted that result in decisions about whether to continue certain activities or accommodations, discontinue them, or add new ones, right? All of that is important because if the supports and services in place aren't yielding positive outcomes, they need to be changed. If they aren't working but are continued, the student's not going to progress as much as they could, and the gap between what they're learning and what his or her peers are learning, the ones that don't have disabilities, that gap continues to get bigger and bigger. So even though they have to meet once a year, if you see your child isn't progressing or that the decisions made at the meeting are not being implemented, you have right, and I'm going to say the responsibility, to call for another meeting anytime your child's progress or lack of progress needs to be discussed. FAPE, talk about that term for just a minute. FAPE is the Free Appropriate Public Education. FAPE is individualized and based on data and the needs of the student being discussed. It will and should look different for every student. An individualized accommodation plan. That's what they call that 504 plan. An IAP should look different for every student. The 504 committee will determine FAPE through a review of the data and discussions among the members, which should be including the parent, right? FAPE is important because it's like a roadmap on a trip, right? FAPE will set the course that must be taken to get to the desired destination. If FAPE isn't appropriately decided or implemented, the student's never going to get at the destination of knowing what their peers are knowing at that time. Like we discussed, once your child has been determined eligible for 504, the 504 has to meet once a year to determine progress. I'm not often surprised when a parent tells me that they haven't met once a year. So really, it's not responsibility, but it is responsibility for a parent to make sure that it happens, because I know it doesn't happen. As a matter of fact, I know some parents that tell me, well, they had a 504 plan in 5th grade, but we're in 8th grade, and I don't think we have that anymore. It shouldn't disappear, right? Okay.
How legal is it whenever we're hearing things like, no, they didn't do a meeting last year, they called me and said nothing changed? Like, that's it, that was the call.
As long as mama agrees, yeah, they can note that and they can get away with that. You know, it's mama's place to be able to say, no, we need to actually have a meeting, particularly if it doesn't really seem like things are going well. You know, that should be his quickest trigger of, no, this doesn't sound right. Things haven't changed, but, you know, my child has changed, or this still isn't working, or whatever. But yeah, I don't give up my right to have a meeting. That kind of discussion always sounds like a favor, and it's not.
Is it once every school year? Or can it happen like at the end of one school year and the beginning of another?
Oh, good question. 12-month period. So they have to have a meeting every 12-month period. One. You can have more than one, but one every 12-month period. Okay. Once your child's been determined eligible, the 504 must meet once a year to determine progress. There's also the requirement about reevaluation every 3 years. The reevaluation should include some new testing and a review of your child's progress over the past 3 years. It's critical in that without current data, decisions won't be the best they can be. And the best way to perceive positive results is through data-driven decisions and courses of action. Old data or missing data is only going to get in the way of your child's progress, and that's not something that ever should or that we want to happen. So, your child's been determined eligible for 504. How long does that last? Some people think that once 504, always 504. That's not correct. Your child should be reevaluated every 3 years. And if in any of those reevaluations, your child no longer meets the criteria for 504, they can and should be dismissed from 504. This can happen as a result of a significant change of information, even in the middle of those 3 years. This can happen when a medical diagnosis is changed or eliminated. If that's the case, I always ask the school to conduct a reevaluation at that time, so specific reasons for the discontinuation of your child's eligibility can be documented. It's good for you, and it's good for the family, and it's good for the school, because they can document the decision was data-driven and not just an arbitrary decision. If your child's found eligible for 504 because of behavior, the team should be with the assistance of someone with knowledgeable of behavioral principles. That's probably a social worker, a psychologist. They have those in the school system, right? Develop a behavior support plan which identifies the behaviors of concern and strategies which will assist in the reduction or elimination of those behaviors. Like any other concern, the student's progress should be monitored frequently. The school should provide you with documentation of his or her progress, and meetings should be called whenever his or her progress is insufficient. So sometimes people think verbs are about special education. Verbs can be about 504. Those daily charts, if that's what it takes to be able to show that they're responding and making progress. Once the student's been referred for the evaluation, protections under 504 and the context of discipline starts. That protection continues until the student is determined not eligible or eligible, right? Eligible means it keeps going. This can be at the end of the initial evaluation, or sometimes years later when data indicates he or she no longer meets that eligibility criteria, right? Is that as clear as mud? I could explain that better. But they get protections as soon as the evaluation starts. That's the important part. The protection only applies for an evaluation that was made before a disciplinary incident. So if your child violates a school rule this morning and you ask for an evaluation, and you can prove it this afternoon, your child will be disciplined the same as any other student. If you ask for evaluation this morning again and you can prove it, and your child violates a school rule this afternoon, he's got some protections. That's important to know. There's still not protections for weapons or drugs. Just so I said that, by the way. Your child's going to be disciplined the same as any other child. But everything else, we can talk. If your child is eligible for 504 services and commits an infraction that might get him or her suspended or expelled, they will do an MDR. An MDR is a manifestation determination review. They have to look at certain pieces of information. So what's that MDR and why is it important to your child's due process rights? It's a meeting to determine whether or not the behavioral infraction is the result of a choice on the part of the student or is part of their disability. If the determination is the behavior wasn't part of their disability, they can be disciplined like any other student who doesn't have a disability. If that behavior is the result of their disability, then no disciplinary action may be taken against the student. That's going to sound strange to some people because they're going to say the school still sent my child to an alternative school. Not exactly. What happens is essentially they convince the parent that it's a good idea for, I can name 10 reasons, for that child to go to an alternative school. And that's why your child ended up at the alternative school, not because they could discipline your child. So you could say no, maybe. Like I said, that's true except in places where the federal law has mandated certain consequences. So it could be drugs, alcohol, weapons, real weapons, not fingernail file, and incidents resulting in serious bodily injury. You have the right to be present during an MDR meeting, you mom. And you have the right to have advance notice. You can bring an advocate, an attorney, a friend, your child, or anyone else if you so choose. The MDR is supposed to take place within 10 days of the disciplinary infraction. It might be sooner than 10 days, but it shouldn't be conducted until the administration has had sufficient time to complete their investigation into the incident. The MDR could look like a regular 504 meeting, but someone with your knowledge of your child's disability and how that disability might impact his or her behavior should be present. That might be a psychologist or a social worker. Once all the information pertaining to the incident has been shared with the participants of a 504 meeting, then it's the responsibility of those people to answer 2 questions. First question is, do they have a 504 plan that's reasonably calculated to provide the opportunity for the success of the student in spite of his or her disability? The second question was that plan implemented with fidelity? If the answer to either of those is no, then the finding of the team must be that there is a causal link between the behavior and the student's disability. So, if your child has a disability that shows itself through inappropriate behaviors, there should be included as part of the 504 plan a behavior plan, which might be called a FIP or a behavior intervention plan, or a behavior support plan, or whatever your school district might call it. If your child has a disability and doesn't have a behavior plan in place at the time of the infraction, well, in that event, it can and should be argued that the 504 plan wasn't developed with sufficient supports to ensure the opportunity for success, right? We're not talking about a 504 plan that's just about academics. We're talking about behavior, okay? So then the answer to the first question in this case would be no. So it should be determined there's a causal link between their behavior and their disability. So similarly, if there is a plan, but it's determined that the plan wasn't followed as it was written and discussed, if that's the case, again, there's a link between the behavior and your child's disability. In neither of those cases, no disciplinary action can be taken unless it's one of those 3 things I talked about earlier. However, that shouldn't also mean nothing is done. What needs to happen is that the 504 team should develop a new behavior plan, revise the existing behavior plan in order to provide the level of support necessary to prevent future occurrences of that behavior. But if there's no link determined, then the same thing's going to happen to this student as going to happen to any student with no disability. That MDR process that's in part of the entire due process afforded to students with disabilities helps level the playing field, which is the foundation. I know I've said it 10 times. The foundation of the 504. We're getting there though, you guys, just a little bit longer. No matter how hard everyone tries, there's always going to be times when parents and school personnel don't agree. If all forms of communication fail to bring everybody to an agreement, then the parents have the ability to file for due process rights. Each district's due process looks a little different, but if you look at that parent-student handbook that you're supposed to get every year from the school district, if you have a child in school, you should be able to find the process used in your school district. If you go to the school system's website, you should also be able to find the process in the policy section. Most of the districts have levels in that process. The key thing is to read their procedures carefully and follow them like it's written. And insist that they follow their rules as they wrote them. If there's a timeline to file an appeal and you miss the deadline, you're going to forfeit your right to move to the next level of the appeals process. So be certain about the timelines. And I'm talking down to the level of Are we talking school days? Are we talking business days? Are we talking calendar days? You need to know what kind of days are we talking about. If you feel the need to go to the OCR, the Office of Civil Rights, it will help you to show that you follow the school district's appeals process, and it's going to just demonstrate your willingness to work with the school system. That kind of stuff never hurts when you're going to Office of Civil Rights or other due process processes. Okay, another poll. Parents' rights information must be provided at every 504 meeting held. True or false?
And we got a hand raised too by somebody.
Okay, let me finish the poll and we'll
Okay.
do that. So are they going to give you parent rights at every 504 meeting?
I think they should.
Yeah, I see some false and some true.
It's true. They need to be provided to you at least once a year at the annual review meeting. If you lose your copy or want another copy, you can always ask for an additional copy. There's typically a copy on the website too. But yeah, they should give it to you at least once a year. And generally, if you're having more than one 504 meeting in a year, something's not working right. And yeah, they should be giving it to you again. You said you had a question, Mom.
Well, it's someone had a hand raised, so I'm asking them if they want to talk or unmute.
Okay. Let me know when they answer you.
Okay.
Let's see. So go on to reflections, Wallace. Live? There you go. Okay. You can talk to me about any one of these topics. This is just for us to think about. You don't have to say anything in any great detail. It's up to you.
And that's kind of what we went over today, sort of those things.
Yep. If you got something to say about any of them, I'm sorry.
What are some common accommodations that you're seeing for things like ADHD or a lower level of autism, things like that?
For preferential seating, extended time, repeated directions, depending on the ADHD, formatting, color coding, that seems to help sometimes with people with ADHD. It helps them concentrate. There's a couple of places where I can find you lists of accommodations and get them to you, but I'm not going to remember. You're going to have to remind me. But that offer's open to anybody. You say your child has X and want to know what kind of accommodations might work, hit me up.
So things like an impulse control issue, something that's been documented by a physician saying like this is definitely one of those things that is involved in the diagnosis. What are some common potential accommodations for that other than like the redirection? Because you can say that, but like what other, or is there anything else other than redirection?
So impulse control disorder should imply some type of behavioral teaching that should be part of not so much an accommodation, but part of the processes that are going on with the student. Teaching them, it's kind of like anger. You teach them techniques that they can use to control, delay, and regain control over their anger. The same thing with impulse control. There are behavioral teachings, steps, kind of like this is what I do when I start to feel this is what I do when this is how I think something through. Used to be very old, but used to be a system called skill streaming. I'm sure there's much better systems available now Cause it's been a while since, I did that level of, work with one of my kids.
And we have,
And again, you need to hit me up where I can think better. Okay.
and we have two different questions by two different people in the chat. The first one, what are some common accommodations for dyslexia and dysgraphia?
So there's a whole handbook and a website from the Louisiana Department of Education about dyslexia. You need to hit us up. Like I keep saying, I'm not going to remember. You'll need to hit us up so we can get you to it. Hit me up, send me an email, ask me or Wallace, so that we can get those kind of that level of resources to you. But there are people much smarter than I am about those things.
And then the other question by another person, can a student have a 504 and a IEP simultaneously?
So, my answer used to be no, because you're supposed to be able to get all of the 504 accommodations that you need with an IEP. But I've noticed in the school systems lately that there are students that have both. It's typically, not always, so don't take this as the only example, but it's typically a student that has like a speech IEP and has behavior concerns, and they'll have the IEP for the speech and communication part, and then a 504 plan for the behavior part. So I guess my answer has changed just because I've seen it change in the school system.
And could gifted with a person with a disability and gifted, that could be another one, right?
Another one.
Where they would have both, maybe? No?
If they had some other concern and gifted. Yeah, because with gifted in our state, not in the other states, maybe in other states, but not always. In our state, gifted people get an IEP, and then yes, they might have a 504 plan for some other, we call them classification, exceptionality, whether it's behavior or academics or whatever. So yeah.
Do you see a lot of pushback from the schools if they say not every student needs a plan, or it's just they're choosing to act up, or they're choosing to do wrong, but they have potential to act right, and so I don't need to have a 504 plan in place? Or what do you tell those?
Pushback from the school. Okay, not every child with a disability needs an IEP or a 504 plan. So I don't consider that pushback, no. Are there children that might need those kinds of supports that that there's a disagreement between a parent and a school system? Yeah. So documentation. My big thing is always not ever having to go to the next step, because I'm documenting the steps that I'm on so thoroughly that I don't have to go to the next step. But so my thing is documentation. Do you have a psychologist, psychiatrist, GI doctor, since somebody mentioned somebody's stomach, to be able to accurately be able to identify the disability and to accurately be able to have a conversation about the disability? Not that you should have to wait for that, but that's the documentation that you should be acquiring while you're asking for evaluations. Private evaluations. Not that I expect you to wait for those private evaluations while you're working through the process, but those are all documentation that you can use in the process of that conversation about whether he's choosing or not. If it was as easy as people in general being able to choose or not, we wouldn't have disability in the first place. We could always say it's a choice, and we know that's not true. And when should parents go to the next step? So one of the things that I do, only me, because I don't know, we all have our own way of working with family members, is that if a parent tells me, I'll sit down and help them write out a plan of like 3 or 4 steps about what are the next 3 or 4 things that they need to do. An individual plan for them and their kid, the next 3 or 4 things that they can do to reach this goal, whatever that goal is. So, don't come to me and say, what can I do to help my child who has ADHD? Okay. All the things that everybody tells you. Okay. Come to me and say, I'm trying to get an evaluation for my child, and my child has ADHD. Then we can talk about the next 3 or 4 steps for you to be able to start accomplishing it. So that's one of the things that I do when I'm working with a parent, that makes me aware that they need a written plan like that. I do a lot of phone consultations. I do a lot of individual consultations where if you have a plan, I will sit there and read the plan with you, every single solitary line, everything that they're trying to tell you on that plan, what it means and how you and your child can use it. Do the same thing with evaluations when parents need me to do that. They'll do that as often, whether they're private evaluations or whether they're school system evaluations. And it's because I think about it like a parent thinks about it. I've got 30 plus years of experience. It's not because I have anything spectacular. I just think about it like more like a parent thinks about it, and can go over it and help them make sense of it sometimes. Yeah, that individual plan, 3 or 4 steps, almost invariably one of those steps is going to be about documentation, just to tell everybody ahead, because that documentation is what, I've been in meetings more than once and been able to say, Mama can document A, B, C, X, Y, Z, L, and M as well. Mama's ready to go to the next step. What can we do here? And we've started coming up with solutions. But it's because Mama could and did put together that kind of documentation.
Who I guess conducts the evaluations or like the investigations?
Pupil appraisal is the entity within every school system that does evaluations. Now, there might be several layers in pupil appraisal, depending on how big a school system is. So in one school system, pupil appraisal might be 2 people. In another school system, pupil appraisal might be 15 or 20 people. But pupil appraisal is the entity that does the evaluation. There is an entity in the school system called Child Find that is supposed to actively look for students with disabilities that might need extra help. But I typically have, I typically get straight where I want to be when I'm asking for pupil appraisal.
And you touched on this, and I'm sorry, I'm still not getting it. The FAPE, what? I'm still not understanding that.
So the term FAPE, free appropriate public education, is an important term in the law, because the law guarantees that your child is going to get FAPE. So the law guarantees that it is going to be free. It's not going to cost you. I mean, you're going to pay fees just like every other parent with a child in school might be pay fees. You know, $30 for the class fee or something like that. But you're not going to pay anything extra for your child to receive special education services, for your child to receive 504 services. Appropriate's a really cool word. Appropriate means it's about your kid. This isn't the service that we provide for every child that has autism, or the service that we provide for students with intellectual disabilities. No, it doesn't work that way. It's about your kid. Appropriate for your child. Public means that it's open to public review. So like I can't go to the school board office and find out how much my child's teacher gets paid, my child's special ed teacher, or how much the program facilitator gets paid. But I can go to the school board office and know that special education costs this amount of money, and program facilitators as a whole make that amount of money. And these are the related services that can be provided, and how much money is going to these related services. So it's not down to the level of a specific child or a specific school personnel, but I can still know as a whole. Appropriate public education. Same kind of thing that we're doing with every kid. We're not just providing baby services or babysitting services, because daycare services, that sounds better. We're not providing daycare services, that there is education, even for the most significant disabilities. There is detailed information on the Louisiana Department of Education website about what they're supposed to be doing and what kinds of things they're supposed to be teaching.
And then, sorry, I wanted to make sure I changed.
No, knock yourself out.
The difference between a 504 and the IEP is still blurred for me. So
Okay.
like the 504s you have, if it's a physical, if it's a mental, or what?
So think of it like an umbrella. Here's all the kids at school. Then there's smaller umbrella. There's kids with disabilities. There's a smaller umbrella, and these are the kids that's disability is severe enough to qualify for a 504 plan. And there's a little bitty umbrella. These are the kids that are so severe that they need an IEP. They need something with lots of detail, lots of facets to it. They need lots of accommodations and quite possibly even modifications if they have a severe intellectual disability. You know, I mean, to the point where we're changing what they're learning on a whole scale is when they get those modifications. Okay, but that's a tiny group compared to those bigger umbrellas. So the difference is the level of the amount of their disability and the level of support that they need. Does that help?
So you can have a modification in the 504, or is that just an IEP?
You should not be getting, now they use the words interchangeably,
Right.
but you should not be getting a modification with a 504 plan.
Okay.
A modification means that I'm changing what you're learning on a huge level. Sure. Anybody else wants?
Be anything in the chat.
Okay. So just for my last little bit here, I appreciate y'all showing up and hanging with me through all of this. Okay. I know it's complicated. You're welcome to call me Wallace and Farrell, if you need to. We have an evaluation. As soon as you click off, the evaluation should pop up. Quickie. If you don't happen to miss it for some reason, Wallace will email you the evaluation. If you do the evaluation, I mean, these are important to us. This is how we justify the fact that we do these things. This is how we get funding for these things. This is how we learn about what's important to you. You can write stuff in the blank spaces on the evaluation. More than one of us review the evaluations. Can you tell I'm really tight to my evaluations? So please, and you'll get, if you're not here and got a copy of the PowerPoint, well, even if you're here and get a copy of the PowerPoint, Wallace is going to email you a copy of the PowerPoint, so it has hot links in it, and certificate of attendance. If you send me my evaluation, and unless we got more questions, we good. You can turn off the recording or whatever it is that you do.